Hello, Eric Smith here with Bar Exam Review, Complementary Model-Based Systems Engineering of Law, the graphical approach to law. And here we will look at a multi-part fact pattern. Number 1 says, Johnny shouted nasty epithets at Ben, and Ben realized that Johnny could get out of his seat and come for him. Ben was not fearful. Can Johnny be found liable for assault? So we look at the graphical definition of the tort of assault, and we find here that the defendant, Johnny, had an intent to cause, and we can assume that Johnny did cause the apprehension in the plaintiff, Ben, of an immediate harmful or offensive contact. Now note here that the fact pattern tells us that Ben was not fearful, and in fact the exception here is that fear does not have to be present. What has to be present is apprehension. Apprehension is the comprehension, the logical comprehension of an immediate harmful or offensive contact. So the actions of Johnny are driving toward that type of apprehension. Fear does not need to be present. However, when we look at this side of the graphical definition, we find that the defendant, Johnny, needs to have performed an act, because the exception that is specifically noted here is that words alone cannot constitute the necessary act, physical act, for assault. So the fact that Johnny is only mouthing words negates the necessary act on the part of the defendant, Johnny. And so at this point, Johnny cannot be found liable for assault. Now going back to the fact pattern in number 2, assuming the facts above, in addition to shouting epithets, Johnny wielded a knife. Can Johnny now be found liable for assault? And this additional fact of wielding a knife now gives us a physical act which Johnny is performing intentionally and both causing in fact and being the proximate causation or legal causation to the apprehension, the comprehension on the part of Ben that an immediate harmful or offensive contact can occur without Ben's consent or privilege. So in this step number 2, yes, Johnny can be found liable for assault. Now we extend the facts in number 3. Johnny was behind a tall and continuous chain link fence during the occurrences. Can Johnny now be found liable for assault? Well, in this case, Ben, being an intelligent person, would comprehend or apprehend that an immediate harmful or offensive contact could not occur because of the presence of the fence. And so this negates the qualitative part of the apprehension or comprehension of an immediate or harmful contact on the part of Ben, and so now Johnny cannot be found liable for assault. Then number 4 extends the fact pattern. Assuming the facts above, Johnny became frustrated and threw his knife to the ground, accidentally causing a rock to strike Ben. Can Johnny now be found liable for assault? So we go back to the graphical definition of assault, and we find here that what we actually find is a blank space, in that the things that were caused on the plaintiff, Ben, do not include a physical contact. So in this case, we are not dealing with the proper tort. The proper tort would be battery. And so we have to move to the proper tort, which is found here. And this is the graphical definition of battery. Now we have here that in this case, Ben was in fact touched by the rock. This touching could be found to be offensive, or perhaps even harmful. This judgment has to be performed by an objective judgment by a reasonable person, by the reasonable person standard. And we find here we have to go back and examine whether the defendant Johnny meets these necessary elements. Did Johnny, with trespassory intent to touch, cause this harmful or offensive contact on the plaintiff Ben? And here we find that perhaps Johnny's intent when he threw the knife to the ground was simply to throw the knife to the ground. It was probably not an intent, was probably not a trespassory intent to touch the defendant. Perhaps it was. This may be a judgment call on the part of the finder of fact to find whether this intent was trespassory or not. I will call it here to be not trespassory intent, and emphasize the word accidentally caused the contact by the rock on Ben. And in this case, I would call it to be that Johnny is not liable for battery. Now, we go to number 5. Johnny picked up a grain of sand, threw it, and struck Ben. Can Johnny be found liable for battery? Well, in this case, the contact is very slight, in fact, caused by only a grain of sand. However, we'll go back to the definition of battery, and we find this, that the defendant Johnny, in fact, with trespassory intent, that is, intent to trespass on the person of Ben, performed an action to touch. This grain of sand did, in fact, cause a contact on the plaintiff Ben. The intent did cause this offensive and harmful contact on the plaintiff Ben. Now here we have to see that certainly the contact was probably not harmful, but it may have been offensive under the objective judgment of the reasonable person. Probably because of the preceding facts, the grain of sand contact was probably offensive. And we see the full definition at the bottom. Battery is the trespassory touching of a person in a harmful or offensive way without consent or privilege. And the damages can be of many types. The damages can be nominal only, and that would include the touching of a simple grain of sand on a person, causing nominal damages. So in this case, yes, Johnny can be found liable for battery.